present. Today is the 5th day of the 1-week-long faculty development program on research methodology and project writing skill development, organized by Jim School of Law, Greater Noida. I extend a very warm welcome to our respected HOD, Professor Dr. Pallavi Gupta ma'am, all the members of the organizing committee, and all student participants in today's session. The speakers for the day are Ms. Diksha Sareen, Professor Dr. Nk Behelzer, Ms. Priyadarshini Tiwari, and Ms. Soumya Sharma. So without any further ado, I would like to invite our first speaker for the day, Ms. Diksha Sareen, to share her insights on data collection. I shall share the PPT on your behalf. Please go ahead.
Purva ma'am, I'll share it on my own. If I'll face any problem, then I'll let you know.
Sure, ma'am.
Okay. All right. Thank you so much. So I'll share my screen first. Good morning, a very good afternoon to one and all present here. So today I'll be discussing about data collection and data analysis in legal research. So as of today, you have you are already aware of what is research. So research is basically when we try to, in a very scientific or logical manner, we try to find out new insight about a particular topic. So I will not go much in detail of what is research and the things that you have already covered. So I'll skip to the part of data collection. We'll try to understand what data is to be collected, what are the different techniques in doctrinal research as well as in empirical research. If we go for doctrinal research, the data collection strategy would be slightly different. And similarly for empirical research, it would be different. So we will discuss how data is collected, what or the manner in which it is to be analyzed once we collect the requisite data, and how we need to go about it later on. So I'll start with it now. So basically, it is very necessary that the procedure used for data collection should be extensively scrutinized. Whenever we are choosing a particular method of data collection, we need to be very thorough about it, that what is the method that we are to choose, and will it satisfy our purpose based on the method of research that we have chosen. So existing data resources cause confusion in data selection. We have a number of existing resources, and it is very much possible that the researcher get confused that which is the relevant data for us and which is not. So while dealing with the data at various stages, each of which may raise questions of validity, we have to be very careful and we need to scrutinize it well in advance. Inaccurate data collection can impact the result of a study, and it may ultimately lead to invalid results. So whenever we are the then obviously we will be facing various issues. So there are various facts, data, and information relating to research topic available in the world. Research is required to make the proper, objective, logical, and authoritative decision that what facts may be relevant for his study or not. So after selection of a principle of data collection, consistent application of standards within that method must be developed, so that the measurement reflects the intended variable and it is not based by the methodology employed. So for that, the methods of data collection in legal research, it will depend upon the nature of topic that we have selected and the data that we need. So the methodology followed in any research and methods form a part of, and it depends upon the questions necessarily be answered as to the nature of data, their collection method, and analysis process. which may differ from one stream to another. In legal research specifically, research process is, as we know, is centric either on doctrinal method or empirical method. And most of us, we do follow the doctrinal method, though it is nowadays it has been advised that even in legal research, we should go for empirical method. But still, most of us who are doing legal research, we still do prefer the doctrinal method. So basically, methods of data collection can be classified on following broad aspects. Firstly, it depends upon the nature of research problem and the research objective. Secondly, the authority of data that you have chosen, be it a primary data or you are going for the secondary data, that will depend upon that. And thirdly, the reasoning followed in data collection. So you have, as we know, the methodology includes the process and the reasoning for data collection. So the method that you have chosen for data collection, it involves or includes each of these points. So based on this, we can classify our research into two categories. It can be doctrinal and empirical method, and the second one can be primary and secondary data. So as we are already aware, like my fellow colleagues have discussed with you what is doctrinal method, what is empirical method. So I will not go in detail of that. So we will just to give you some idea about it, I have included a PPT regarding that as well. So basically, doctrinal method is, or we can say it as a library-based research. So obviously, our methods of data collection would vary in a doctrinal research. So since in doctrinal research we use as library, we access the already available data which is there in our archives or books or commentaries. So the process of data collection would obviously be different in this process. We need to analyze the various provisions that are already in existing. We need to go into analysis of the judgments that have been propounded by the court. So for that, I will discuss how we need to analyze the judgments that are given by the courts. Yeah. So in doctrinal research, we have the methods or the sources how we collect the data would be, firstly, we divide it into two categories. One is participation and second one is publication. Participation is direct attending, like you participate in lectures, seminars, conference, judicial, legislation, or administrative proceeding, that come in the category of participation. And second one is publication. So publication is by virtue, in this category, we includes our books, the journals, the magazines, newspapers, other juristic works, or maybe reports of various conferences, seminars, reports of judgments and commentaries and case laws. Further, in doctrinal legal research, basic authoritative source of development in field of law are considered as primary sources as legislative enactments, judicial decisions, customs. So above three are the most authoritative sources of legal data. Legal data from all the other sources may be less authoritative. We are not saying that it is not authoritative at all, but it is less authoritative than the one which is there than the above three mentioned. The law emanating directly from the competent authority is termed as authoritative sources. Authoritative sources are binding in force, they have a binding character, and in present time, legislation and judicial precedents are the foremost primary sources of law. So as far as customs is concerned, it may or may not be a primary source depending upon its status. Whatever be the status of that particular custom, it will depend upon that. Further, since we know that in doctrinal research, we have to analyze the various judgments that are available to us. That is our major source of data collection. For that, we must be aware that how we need to analyze those judgments. So whenever we take up or read any judgment, we need to firstly see what are the facts of that judgment. So obviously, if you will look at a judgment, some judgments are of, say, it goes in hundreds of pages. So you have to be very smart while studying those judgments. You have to read the facts very in a very smart and concise manner, and it would be preferable if you for your study purpose or for your reference purpose, you summarize it, say, in 500 or 600 words, depending upon the depending upon the length of that particular judgment. So you firstly need to sorry so you firstly need to summarize the facts that are involved in that particular judgment. So the first important step of judgment analysis would be that. In that, we include the name of the parties, the case in which the subject matter of that particular dispute. Then second is issues. So issues is basically what the parties are disputing about. In every judgment, you will see that the courts have framed certain issues. So you need to clearly demarcate that these are the issues that were involved in that particular judgment, and after that, the next step would be parties contention. So whatever both the parties to the case are contending to that particular issue, you need to summarize the contentions of both the parties, whether they are opposing it or whether they are admitting it, or whatever be their arguments. So the next step of the judgment analysis would be parties contention. Again, the parties contention can go in n number of pages. You need to summarize all of these things. If you want to include it in your research, or say if you want to refer a part of it, then also you should firstly analyze that judgment in this manner, and then include it in your dissertation or research work that you are doing. After that, once we are done with the parties contention, then we need to move on to the judgment part, that what rule of law the court has applied, how the court has interpreted those, and after that, the rationale, the reasons for holding that particular judgment. What are the reasons that the court or the judges has given while giving that particular judgment or order? And then comes lastly your own analysis. So just merely writing down that this particular thing was held in a particular case is not sufficient. If you are to include a particular judgment in your research, then you must also add up your certain analysis or conclusion about that particular judgment, that according to you, what would be the effect of this particular judgment, how it will be beneficial for us, or what are the shortcomings of that particular judgment. So this is one very important thing that you must include whenever you are analyzing a judgment in your research. This is one such point which we often fail to include. We usually mention that in this particular case, the court has held this particular point. However, we usually do not include this point. Then you must be very careful about it, and you must include it in your judgment analysis, which you are doing in your research paper. Now, coming on to the empirical method, as we know, the empirical method, we also call it as non-doctrinal method, and it is a source of knowledge by data acquirable. We acquire the data, then we have to verify the data by means of observation or experiments. As you know, that there are various methods of collecting data in empirical research. It can be through interview method, it can be through observation, it can be through survey schedules. So based on whatever method you are choosing, through that method you will collect your data. And in empirical research, researchers they usually rely on his or her own experience with respect to the facts and variables which are there in that particular condition or experiment which they are indulging into. So empirical data is considered as slightly more authoritative for research over doctrinal data. That is why in all the other fields except law, like in most of the other fields, they do prefer empirical research only. And now the trend has started to change in legal research as well. So we do prefer empirical research nowadays because it is considered as more verifiable or authoritative as compared to the doctrinal data which we have. So researchers, while doing an empirical research, researcher has to undergo with hard work of finding sources and places and situation to observe the relevant facts. They do it through various methods. So I will not go in much of a detail because we need to come to the data analysis part. So I'll just skip this part as my colleagues have already discussed it with you. So this basically talks about the techniques which are there. You have discussed it. Observation, interview, survey methods can be used. So now, straight away coming to the data processing part. So once the data has been collected through various methods, maybe if you have chosen an observation method or interview method or survey method. So after once you have collected the data, the following steps are to be taken. The data into more measurable and concise manner. We need to make that data um, in a concise manner, because if you are going for interview, the data might be very vast, and through that particular interview you cannot really come to any conclusion. So we need to put in our data which we have collected through the various methods in a more measurable and concise manner. So for that there are various steps. First step is editing. So in this stage of editing, all the raw data that we have collected is to be checked, and we need to go in for if there is any error or omission, and sometimes whether the data is consistent or not. So for example, if you collect data through circulation of Google Forms, like that is done very often, we do send you Google Forms, and through those Google Forms we collect data from you. So this can be a method of data collection. So in that Google Form, some people, like if you are asking that a question can be answered in say numerical form, it can be answered in word form, and some of you might leave one particular question as empty. So in this editing part, we try to see that whether there are any error in the process of data collection, whether there was any omission, whether we have the data which is there with us, whether it is consistent or not. And if there is any error or omission, then we try to make it to rectify those errors. If there are any questions left in an interview or in a Google form, we might try to approach that respondent again and get answers from that. So this is what we do in the editing part of the data process. So it is not only sufficient that you have got the data, you need to verify the data at your end first. Whenever you have that raw data with you, check for errors and omission if there are any, and try to rectify it. Then the second step in this process would be coding. Coding refers to the process of assigning numbers or symbols to the answers so that the response be put in a limited number of categories of classes. So we assign certain numbers or symbols to the data that we have collected from various respondents. So this is the coding part. It is done so that we might be able to present our data in a statistical manner, or maybe through graphs or pie graphs. That will depend upon the type of research that you are doing. It is not necessary in every kind of research to go for coding and decoding. That is usually done in empirical researches only, and that too not in all kind of empirical research. So again, it will depend upon the type of research that you have been undergoing. So once you have edit the data, then you assign certain numbers or symbols to the answers that you have got. It can be pre-coding and post-coding as well. Pre-coding is basically when you give codes to the questions in advance before you actually give them to your respondent for answers. And post-coding it, that you assign certain symbols or numbers to the answers that you have collected from your respondents. The next step is classification. So once the data is collected, it is divided into homogeneous groups. The people who have opted for the same answer, you form groups for that people. So that when like we are researching for market related research, so we know that these are the number of people who opted for answer A, these are the number of people who opted for say answer B. So this is classification of the respondent into various homogeneous groups. Then we come to the tabulation part. Tabulation is the process of summarizing raw data and displaying the same in compact form. It can be in the form of statistical tables or through any other way. So tabulation is an order of arrangement of data in columns and rows and displaying the same in a very compact and concise manner. Now coming on to the tabulation part. Tabulation can be done either by hand or mechanical or electronic devices. If your data is very small and which is something which is easily can be tabulated, so we can do it through hands only. But if your data or your type of study is very vast and it is a very it will be a very time consuming process if your data is very vast, to do it by hand. So in those cases the researcher may go for tabulation through computers. So there are various softwares which help in tabulation of your data. So you can go and do the tabulation part through those software, like one is SSC. So in So there can be various types of tables. One, we usually divide it into two categories: simple and complex. Simple table are one under which the different attributes are stated in the left-hand column, and the frequency or extent of occurrence of each of these classes are written in another column. In this, three things are essentials. The classes made must be mutually exclusive. The tabulation must have internal logic and order, and the class intervals must carefully and reasonably be selected. Say, for example, if you are verifying or your respondents are from various age groups, like one age group is below 10, another age group is 11 to 20, then a third age group is 20 to 30, and similarly your fourth age group is 31 to 40. Then this can be your one column. Age of respondents can be your one column. The second column can be frequency, like below 10 we have 14 people, say from 11 to 20 we have 20 people. So this will be your frequency column, and last would be your percentage column, that how many of like we will uh, put this in percentage form. So this is how your you can formulate a simple table for data collection. Then coming on to the complex table, in that we have more columns. Sorry, yeah. So in complex table, or we also call it as cross table, it is bi or multivariate variate are used. Uh, for example, if we are to study about income with respect to male and female, so income would be our first column. Then the second column can be for males, the third column can be females. In this, if we have to study about that, what would be the income for rural males, that would be our subcategory in that. Similarly, if we have to study regarding the income of urban males, so this would be our one of the column in the one of the subcategories in the male column. So in male column, we can have two subcategories. One is rural male and the second one is urban male. Similarly, when we'll come to our female category, again, we can do this bifurcation: rural females and urban females. And based on the groups that we have made, um, like say if you're choosing, you're making a group of from say 100 to 5,000, then your second group is 5,000 onwards to 5,000, 10,000. So depending upon the groups that you have formulated, you can put the data in your complex table. So complex table have multivariant. In the simple table, we do have one or single variant. Um, so this is the manner in which we can tabulate our data. First, we need to collect the data, and then we will put it in these tables. Then coming on to data analysis. So data analysis depends upon the nature of research that the researcher is undertaking. The types of data analysis is it vary depending upon whether it was a qualitative research or quantitative in nature. So we have descriptive analysis. In this study basically provides us with profiles, like if you want to study about the profiles of company or a group of people or persons, or their size, composition, efficiency, or preference. So you may go for descriptive type of analysis. Under its statistical tools like percentage, pie diagrams, um, or graphs can be used to depict your data and for the analysis part. Then we have inferential analysis. Inferential analysis is basically concerned with the various tests or significance for testing hypothesis in order to determine with what validity data can be used to indicate some conclusions or in after data analysis we have to inference, or we need to draw inferences from our analysis, and we need to ultimately check that whether we are able to uphold our hypothesis, whether our hypothesis is correct or wrong. So once we collect our data, analyze our data, then we need to see that whether we have to prove or disapprove our hypothesis. So general characteristics of analysis of the data would be that researchers should possess knowledge of the area of research as the data collected by him, which will help the analysis of data. You must have a thorough knowledge of whatever data you need and what data you are collecting. So in that way, only you will be able to analyze the data correctly. Then the data is to be analyzed and interpreted. The data which you are collecting should be reproducible so that it can be verified. This is the main important part of your empirical research. If you are not able to verify your research is absolutely bogus. Then the next step, essential characteristics would be that the researcher should keep a clear set of hypotheses formulated at the very start of your research. As you are aware that you need to formulate a hypothesis in a very beginning of your research. So you must have a clear-cut hypothesis. You should be aware that what are the actions that you are aiming for, and based on that, once we collect our data, we analyze it, then only we will be able to see whether our whole research can be proved or our hypothesis is correct or wrong. And lastly, for a successful study of analysis and interpretation should be designed before the data is actually collected. So you must design your research in advance. You cannot go in like, let me collect data and then I'll see what kind of research it will be or what kind of methods I can choose for its analysis. That is not the correct way to go about it. You must have a clear-cut plan that this is the number of respondents that I need. These are the people who I'll be approaching. This is the method which I'll be adopting for collection of data, and this is the method in which I'll be depicting or analyzing my data. So you need to have all this plan in very advance. So this would be it from my end with respect to data collection and analysis. Thank you so much.
Thank you so much, ma'am, for sharing such valuable and enriching information regarding data collection with us. I would now like to invite our second speaker for the day, Professor Dr. Nk Behelzer, to add to our knowledge about doctrinal research in particular. Over to you, sir.
Thank you, Guru. Thank you so much. I'll be sharing my slides with you. Well, dear students and faculty members, today we have entered in the way of our research methodology and dissertation writing skill development program for the students. We have a lot of inspiration and support from Dr. Amit Gupta sir, Honorable the Chairman, JIMS Group, Dr. R.K. Raghuvanshi sir, the campus director, Professor Dr. Kamem, who is Principal of Law, and Professor Dr. A.K. Tyagi sir, and the research cell members of GemTech School of Law. Today's topic allotted to me is how to find out the accident of a case. Dear students, you would be asking me this question in the beginning, I know, that why this discussion is relevant in our dissertation writing. Dear students, you know we have two types of research. One is doctrinal research, what we call as library research or armchair research, and second one is doctrinal, that is field research. So in the beginning, I would like to tell you that in doctrinal research, the finding out of ratio decidendi is important. Suppose you are doing case analysis, or you are looking at the trends of the Supreme Court on a particular legal issue, and what is the judgment law by judicial precedents, because case law and citing of the cases, I think, is part of each and every dissertation, maybe doctrinal or maybe empirical. So what is ratio decidendi? Ratio decidendi is a law evolved in a case. This word ratio decidendi, which is a Latin word, is shortly written as ratio also. And as I told you that in non-doctrinal research also, ratio may not be that material, that important, but definitely it is part of dissertation of each and every student. Dear students, you must know that ratio is never expressly written in any judgment. It is invisible. It is invisible like vitamin C lime juice. Have you ever seen vitamin C in lime juice? Probably not. Have you ever seen the DNA of a human cell? Probably never. Likewise, ratio decidendi of a decided is also invisible. Only a legal eagle can see this invisible magical item, magical word, ratio decidendi. So I'm to ask, are you a legal eagle? If not, I'll make all of you. I'll show you that ratio decidendi is like vitamin C in your lemon juice, and I'll show you that ratio decidendi is like DNA of a human cell. Ratio is not expressly written in a judgment. Ratio has to be extracted from the facts and the conclusions of the court. The entire judgment is not ratio, my dear students. If you see a long judgment, say Keshwanand Bharti's case is 703 pages long judgment. 703 pages are not the ratio of the case. Only few lines are ratio decidendi of that judgment. So basically, there are two parts of the judgment. Central and invisible part is ratio decidendi, and visible portion is obiter dictum. Ratio here means the reason, and decidendi means the decision. So ratio decidendi is the reason or reasons for the decision, and remaining part is nothing but obiter dictum, which means things said by the judges. Plural of obiter dictum is obiter dicta, as you will see in the coming language. So dear students, when you have find out the ratio of a case, and ratio of a case is consistently followed by the future courts in future cases, it gives rise to law according to doctrine of judicial precedent, you know. So ratio decidendi is the reason for, but there are certain observations of honorable judges which are material for arriving at decision. They are not material for arriving at decision. They fall in the category of obiter dictum. I'll give you a few examples before I come to the main topic, how to find out the ratio decidendi of a case. Sometimes you see in a long judgment, the judges usually they are writing, let us see the position of law in United States. And then they cite 10 or 12 cases from Supreme Court of United States of America. All those cases are cited in their judgment. All those judgments which are cited from other countries, they constitute obiter dicta. And then you see honorable judges proceed to compare the position of law of India with that of House of Lords of England. And then they will cite 5, 6 or half dozen cases in support of their contentions. So citing of English cases is also obiter dicta. Hypothetical situations cited in a judgment are also obiter dicta. Reference to books, commentaries, dictionaries, encyclopedias for looking at the meaning of a particular word, all are part of obiter dicta. I'll give you one illustration of Nirbhaya's case, Mukesh and others versus NCT of Delhi. While confirming the death penalty upon the accused persons, Honorable Justice R. Bhanumati quoted the views of Swami Vivekananda in para 149 of the judgment. And the court says, I have highlighted it in green color, the best thermometer to the progress of a nation is its treatment to its women. This is the comment quoted by the judge. This observation is absolutely obiter dicta because it is not at all necessary for the confirmation of death penalty. Death penalty could have been confirmed even without this quotation, that the best thermometer to the progress of a nation is its treatment of its women. So this observation of Honorable Judge constitutes nothing but obiter dicta. Obiter means in between and dicta means to say something. For example, personal views of the judges given in the judgment. I am reminded of a very old case of Allahabad High Court. While deciding a criminal appeal, Honorable High Court wrote in the judgment that crime in Western UP grows with the growth of the crop. Finally, the criminal appeal was dismissed. Conviction was upheld. What is the support from this sentence while confirming the conviction order that crime in Western UP grows with the growth of the crop? This comment, my dear students, is also obiter dicta. This is not the reason for decision. This is not the reason for dismissal of appeal. Hence, it is neither ratio nor the reason for the decision as to why the judgment was given, why criminal appeal was dismissed. This sentence, crime in Western UP grows with the growth of the crop, has nothing to do with the conclusion arrived at by the court. Now, dear students, coming to the point, you are reading so many cases while writing your dissertation. I gave you illustration of Keshwanand Bharti's case also, that the case is as long as 703 pages. You are supposed to find out only few lines, relevant lines called as ratio dendi of the case. You know the ratio of this case, that Parliament has power to amend each and every part of the Constitution except the basic features. This is the ratio decidendi of Keshwanand Bharti's case. But how to find it out? I have taken a very simple illustration, a leading case based on section 65 of Indian Contract Act relating to doctrine of frustration. And the name of the case is before you, Satyavrat Ghosh versus Mugniram Bangur and Company Limited. This case relates to specific performance of a contract entered into by predecessor of Satyavrat Ghosh along with a builder Mugniram Bangur and Company Limited. Now, dear students, for finding out the ratio decidendi of the case, you read this case from some journal. Here is an illustration before you, AIR. This judgment was published. Its citation is AIR 1954, Supreme Court, page 44. What is the head note of this leading case in the journal? Head note reads, Doctrine of frustration, a contract gets frustrated due to supervening impossibility like war. This is the head note. Now, the question is, what is the ratio decidendi of this case? For finding out ratio decidendi of any leading case, which you are quoting in your dissertation, first of all, you will have to see the facts of the case. Very briefly, I am telling you the facts of this case. The defendant builder company entered into a contract to sell a plot of land to the plaintiff Satyavrat Ghosh on 5th August 1940. This date is important. I have highlighted the date in date of contract is 5th August 1940 in Lake Colony scheme and received a sum of rupees 101 as earnest money, and the final sale deed was to be executed within 1 month of completion of roads and drains on payment of balance sale consideration. That's very fine. The land to be sold was requisitioned by the government for military purposes because Second World War was already on. All of us know that Second World War started on 1st September 1939 and it ended on 2nd September 1945. But the date of contract is falling in between these two dates, and the date of contract is 5th August 1940. Now, when company refused to execute the sale deed in favor of plaintiff, then plaintiff filed a case for specific performance of the contract in civil court, and plaintiff pleaded that contract was subsisting and he was entitled to get a deed of conveyance, that is sale deed, executed in his favor. The builder company on the other hand pleaded that contract stood discharged by frustration, by supervening events like war and requisition of land by the government. Now see the decisions. For finding out the ratio decidendi of the case, I requested you to see the facts of the case carefully, number one. Then for finding the ratio, you will have to analyze the judgments of all the courts involved in it. This suit was filed in the trial court. Trial court decreed the suit for specific performance of the contract. Trial court says contract does not frustrate and the builder company is bound to sell particular plot of land to the plaintiff. Now, since the company has lost the case, they filed an appeal in the Court of District and Sessions Judge, and first appeal of the company was also dismissed and suit remained decreed. Go step by step. Then the builder company goes in the High Court, files the second appeal. Second appeal of the company was allowed and suit was dismissed on the ground that contract was frustrated because of requisition order issued by the government. Now Satyabrat Ghosh went into appeal before the Supreme Court. That's why the title of the case is Satyabrat Ghosh versus Mugniram Bangur and Company Limited, because the person filing the last appeal is Satyabrat Ghosh. So in Supreme Court, the appeal of plaintiff was allowed and suit was decreed and decision of the trial court was restored. My dear students, for finding out the ratio decidendi of the case, you will have to study all the 4 judgments or all the 3 judgments involved in a case going up to the highest court, that is maybe High Court or finally the Supreme Court. Now Supreme Court, it was held that most material thing was that there was no time limit within which roads and drains were to be constructed. You see, these builders are very intelligent people. They will write the language of the contract in such a way so that they may get indefinite period for selling the plot in question or delivery of flats when they are constructed. They said that sale deed will be executed within 1 month of construction of roads and drains, and no time limit was fixed for the construction of roads and drains. Secondly, the Supreme Court said that war was already going on when the parties entered into a contract. I showed you in the beginning that 5th August 1940 was the date of contract. At that time, Second World War was already going on, which started on 1st September 1939. And thirdly, the requisition order for military purposes was of a temporary nature and it does not affect the fundamental basis upon which the agreement rested or struck at the root of the adventure. So when the war was over, the facts are that temporary order of requisition was taken back by the government and military establishments were removed from the plot in question. And then Supreme Court says that there was no hindrance for the construction of roads and drains by the company, and company was bound to execute the sale deed in favor of plaintiff. Thus, the conclusion of the Supreme Court is that contract was not frustrated at all, and company was bound to sell the plot of land to the plaintiff. So, my dear students, now we have 4 judgments in hand. Judgment of the trial court where suit was decreed. Judgment of first appellate court, suit was decreed. Judgment of the high court, suit was dismissed. And judgment of Supreme Court where again the suit was decreed. Now, ratio decidendi is to be extracted from which of these 4 judgments? My dear students, ratio is to be extracted from the judgment of the highest court, that is Supreme Court, that is final court in hierarchy of courts in our country. And the related thought is doctrine of merger. The judgment of highest court will prevail. Supreme Court, whatever they have said, will prevail. And the operative parts of the judgments of the lower courts will get merged in the judgment of the Supreme Court. So, ratio decidendi has to be extracted from the judgment of the final court. Now, this decision of Satyavrat Ghosh has to be seen from 2 aspects, because we are learning how to find out the ratio decidendi of a case. Number 1 aspect is what the case has decided between plaintiff and defendant. It is binding on them. And secondly, what principle of law it has laid down. See, this case has decided that suit of plaintiff for specific performance of sale of plot of land was decreed. Why? Because case has been heard and all appeals have been taken up to Supreme Court. Or maybe that this litigation might have ended at the level of High Court if the time for appeal before the Supreme Court has elapsed. So all the parties and disputes, all the parties to the disputes and their successors are bound by the court's finding on all the issues raised between the parties on question of facts and law necessary for the decision of this case. Now, this decision of Satyavrat Ghosh is now res judicata between Satyavrat Ghosh and the builder company, and this cannot be subject to further litigation. But the court's finding will not be conclusive as between Satyavrat Ghosh and the company, because this is a judgment in personam, judgment between the 2 parties. Only in certain circumstances such findings may also be binding on third parties when the judgment is in judgment in rem, as against the whole world. If you see section 41 of Indian 4 categories of judgment, they have the effect that they are judgment in rem. That is judgment delivered in probate, jurisdiction, matrimonial, mayoralty and insolvency, PMAI. These 4 judgments are judgment in rem and their ratio is binding on everyone. But the ratio decidendi of a particular case, the principle of law evolved in a case, is binding on third parties also. This judgment is not only binding between Satyavrat Ghosh and the Mugniram Bangur company, but the ratio part is binding on third persons also. Because as against persons, those who are not party to the suit, the only part of the judgment which is conclusive is the general rule of law known as ratio decidendi, for which the decision is the authority. And you have seen that in this case, it was decided that requisition order was temporary event. The occupation of the land by military forces was removed, and this does not frustrate the contract between the parties, and the suit of the plaintiff was decreed, and company was bound to sell a particular plot number to Satyavrat Ghosh. This is the ratio decidendi of this judgment. Now let us compare it with the head note prepared by AIR. Head note says, doctrine of frustration. A contract gets frustrated due to supervening impossibility like war. But the ratio is other way around. The ratio decidendi is the rule of law. that is the proposition applied or acted upon by the courts or regarded as binding by the courts. So this is not the ratio which AIR head note has prepared. The ratio is that contract subsists. It's never get frustrated because of temporary requisition order by the government. And later on that order was revoked. Military establishments were removed. Now what is the problem with the company? Now they should construct trains and within 1 month they should take balance consideration and execute sale deed in favor of plaintiff. So dear students, we have seen two words, ratio decidendi and obiter dictum. And I explained you that while writing judgment, while writing a long judgment, certain hypothetical situations are also added by the judges. All those hypothetical situations are obiter dicta, because those observations are not necessary for arriving at the decision of the case. But the ratio decidendi is the reason for decision. That is a rule acted upon by the court, whereas the obiter dicta is suggestive of the trend of thinking of the court. Now, dear students, how to find out ratio decidendi of a particular case? There are two ways to find out the ratio of a case. First is Womburg test, also known as reversal test. According to this test, we should take the proposition of law put forward by the judges and just reverse it or negate it by putting the word not in it, and then see if by putting the word not, if by reversing it, it would alter the actual situation of judgment or not. Suppose we are adding word not in the ratio decidendi or proposition of law given by the Supreme Court. If by inserting the word not in the proposition of law, if the judgment is reversed, then that proposition of law is the ratio decidendi or part of it. And if reversal makes no difference, then such a proposition is not the ratio decidendi of the case. Now in Satyavrat Ghosh case, if we apply the reversal test, then position will be, what you are going to do? You are just negating the proposition of law given by the Supreme Court. I am doing that. I am putting not in it. After putting not, the judgment will be like this. I quote, quotation begins, the requisition order was not a temporary one and occupation of military forces was not removed. Hence, the contract between the parties got frustrated and became void, and the company cannot be compelled to execute the sale deed of plot of land. By putting the word not in proposition of law propounded by the Supreme Court, the entire situation gets reversed. The entire judgment gets reversed. Because by putting not, contract is not frustrated. The requisition order was not a temporary one. Military forces were not removed. So how can you say that contract got frustrated? It is not frustrated at all. So this reversal test shows that this proposition of law was the ratio decidendi of the case, because by reversal, by addition of word not, has completely altered the actual situation and the judgment. Second test, my dear students, is Goodhart's test. This is also known as material fact test. According to this test, we will have to find out the most material fact which the judges consider as material and their decision on that. And according to this test only, those propositions of law are only authoritative insofar as they are relevant to the facts in issue in a particular case. You will have to sort out immaterial facts from material facts. The name of the party, immaterial. Instead of Satyavrat Ghosh, the name of the plaintiff could have been Ramakrishna Hegde. It makes no difference on the judgment. Address of the parties is immaterial. Address may be Noida, address may be West Bengal, address may be New Delhi, makes no difference, it is immaterial. Plot number, again immaterial. Advance money was 101, it may be 1 lakh rupees, makes no difference. Total cost of the plot, again immaterial, has no connection with the result of the suit. Name of the society, Lake Colony Scheme, or Great Value Sharnam in Noida, makes no difference. Declaration of war is also immaterial because the contract was entered into after declaration of Second World War. So people are thinking that contract becomes void due to declaration of war. This fact is immaterial because the contract was entered. The factum of World War II was known to both the parties. So this fact is also immaterial. What is material? The most material part in this case is and decision thereupon. That requisition order was temporary one and occupation of military was removed, and as such it does not frustrate the contract. Hence the decision of the court on this issue amounts to ratio decidendi of the case, which is binding on all the subordinate courts. Now you may ask one question to me: what is the relevancy of ratio in dissertation writing? Repeatedly I am repeating this question for the benefit of the students. As I told you in the beginning, dear students, that in doctrinal research, when you do case analysis, you find out the trend of the Supreme Court and various high courts on a particular point of law. You are bound to go through this exercise as to what is the ratio decidendi of the case. Without finding out the ratio of the case, your dissertation on a doctrinal topic will be incomplete. Rather, it will be a waste paper. If you do not know how to find out the ratio of a case, you cannot write a dissertation on your doctrinal topic. So this discussion is very, very relevant from point of view of your dissertation writing. So dear students, you have find out the ratio decidendi of the case. This is law. Entire judgment is not ratio. This ratio, when it is consistently followed by the courts, gives rise to law. And you know, law declared by Supreme Court of India is binding on all the courts within the territory of India by virtue of Article 141 of our Constitution. But Supreme Court is not bound by its own decision. The word courts in Article 141 does not include Supreme Court. Because once the Supreme Court is also bound by its own decisions, there can be no review, there can be no reversal of the judgments. And you know that there are instances when the Supreme Court reverts its own decision. I'm taking the old illustration of right to property, where Shankar Prasad's case and Sajjan Singh's case were overruled in Golaknath case. And the ratio of Golaknath was reversed in Keshwanand Bharti's case. तो अगर सुप्रीम कोर्ट को अपने ही ऑर्डर को रिव्यू करने की पावर न होती तो these steps on right to property, whether fundamental rights should prevail or directive principles should prevail, would not have been before you. So Supreme Court is not bound by its own decisions. Remaining subordinate courts all are bound by the decision of the Supreme Court. And dear students, when ratio decidendi of a case, when it is repeatedly followed by the courts, this gives rise to a law which is known as judge-made law. This theory is given by Cardozo, Doctrine of Judicial Precedent. So judge-made law is a good source of law. In England, you know, there is no written constitution, and the judges-made law is the chief source of law. My dear students, I could have ended my lecture here itself, but I am reminded of a story, actual story of my Doon Law Institute at Dehradun. When I was teaching law students appearing in Munsif examination, one of the students, when I took this lecture in probably 1983, one of my students said that he could not understand a word of my today's lecture. And he demanded refund of his fees, which I took from him in Doon Law Institute. It was a big challenge for me, how to explain, how to find out ratio of a case to a student. I asked him, what is your problem? Why you could not understand such an elaborate lecture on how to find out the ratio decidendi of a case? He was a student from Punjab, Sikh gentleman. He replied in Punjabi. He says कि सर गल्लां दा निचोड़ ये है कि मैनू कुछ भी समझ नहीं आया. गल्लां दा निचोड़ ये है कि मैनू कुछ भी समझ नहीं आया. He could not understand ABC of my language. This is the crux of the matter. I said, hold on, gentlemen. What you said is गल्लां दा निचोड़. That is the ratio decidendi what you are saying. निर्णय सार. But काम की बात क्या है? What is the central point in a case? Then he was very happy. Student was very happy when I caught his own sentence कि गल्लां दा निचोड़ ये है कि मैनू कुछ समझ नहीं आया. मैं कही जो आपने सेंटेंस बोला ना गल्लां दा निचोड़, इसी को रेशो डेसिडेंडी कहते हैं. Then he was happy कि सर मेरे को समझ में आ गया. So my dear students, in the beginning I told you that ratio is like invisible vitamin in a lemon juice. You will have to extract it. It's not written in the judgment. And dear students, besides this formula, the Benjamin Cardozo has given additional points for finding out the ratio decidendi of the case. He says that proposition of law, जिसमें आपने नोट लगाया था ना, that proposition of law must be a necessary step to the conclusion. अगर उसके बिना भी judgment लिखा जा सकता है, then it is not the ratio of the case. Then second, that proposition of law must be directly related to the issue involved. अगर issue से unconnected है, तब भी ratio नहीं होगा. Then that proposition must come from dispute of law and not from dispute of facts. This is very important, what Cardozo has said. That ratio has to be extracted if there is a dispute of law. यहाँ dispute of law ये था whether contract frustrated or not. 3 courts ने कहा कि contract got frustrated. Supreme Court finally said no, contract does not frustrate. So ratio will be evolved from the dispute of law and not from dispute of facts. Very important observation given by Benjamin Cardozo. Then that proposition of law must have been argued in the court. अगर argue नहीं हुआ, sub silentio pass हो गया, then that point cannot be ratio of the case. Then facts of the precedent case shape the level of generality. वो ratio decidendi कितना general है, the facts of the present case will shape its level. And then when later courts will follow it, later courts will decide the level of generality again. And dear students, point number 7 is that when a judicial precedent has multiple reasons, all reasons are binding and there may be more than one ratio in a case. Ratio may come in multiple forms like a common law rule or interpretation of the statute or interpretation of rules. Then you see in Keshwanand Bharati's case, there were 13 judges. Judgment came 7:6. So we have multiple judges. Ratio decidendi is to be extracted out of majority opinion. You will have to read the judgment of all the 7 judges separately and then see what the majority is saying. And dear students, when ratio cannot be determined, later courts may not be bound by the decision of the former court. And unstated assumptions are also not the ratio. You must write down those assumptions which you are propagating in your judgment. If they are unstated, they cannot be the ratio of the case. So dear students, ratio decidendi is binding on future courts, whereas obiter dictum has only persuasive value. And I told you that the obiter of the apex court is binding on future courts. One more point before I stop, that we have declarative theory of judicial precedent. It says that judges do not create law. Judges apply the already established rules of law. They ascertain the relevant rule and apply it to the facts of the present case. This view of judicial reasoning can be stated in a syllogistic form. I am illustrating it with the help of one illustration. Suppose point number 1, I am telling you that all fact situations of type A entail legal consequences B. In this case, this fact is a situation type of A, therefore the legal consequences will be B. This is the basis of judicial reasoning or judicial precedent, which involves the law or judge-made law. Again, another illustration is, you see it in your syllogism also when you attempt logical questions. Common question being asked is, illustration A, all dogs are animals. B, all animals have 4 legs. Therefore, all dogs have 4 legs. This may look to you as oversimplification of the matter, but dear students, in bulk of cases where rule of law is certain and the fact situations can be grouped easily, then syllogism is the appropriate answer to arrive at a conclusion. How judges arrive at a conclusion? If there is an illustration A before them, they will follow it. They will follow the judgment of previous courts. What happened in this case? If we apply this rule of syllogism in the present illustration, so in all cases, wherever the specific performance of contract is denied due to temporary requisition of land by the government, legal consequence will be that requisition order is a temporary event and it does not frustrate the contract. And in future cases, if the facts are that specific performance of the contract is denied by the court due to temporary requisition of land by the order of the government, so the legal consequence will be that requisition order was temporary one and it does not frustrate the contract. This view of judicial reasoning is known as syllogism, which judges generally apply while writing a judgment. So dear students, before I close, one more point for you, that kindly do not be misguided by the head note of a law journal. I gave you illustration that head note prepared by AIR is something different, and ratio decidendi of the Satyabrat Ghosh was absolutely reverse of it. Why I say so? Because head note of a law journal is sometimes misleading. Truly speaking, head note is the mind of the editor, whereas the ratio decidendi is the mind of the judges. So dear students, you should be very, very cautious while reading a judgment. Head note can help you, but you should find out your ratio decidendi independently. I am repeating it. The head note of Satyabrat Ghosh was that contract gets frustrated due to supervening impossibility like war. Whereas the actual ratio decidendi is that World War II was over, temporary order of requisition was taken back by the government, military establishments were removed from the plot in question, there was no hindrance for construction of roads and drains by the company, and company was bound to execute the sale deed in favor of plaintiff. So the ratio decidendi is that contract was not frustrated at all, and company was bound to sell the plot to the plaintiff. Now I am reminded of one more college where I delivered this lecture. Students asked me, sir, what is the proof of judge-made law in India? I said, I'll give you the proof. See, Savitri versus Govind Singh Rawat, in which the Supreme Court of India awarded interim maintenance to the ladies during pendency of application under section 125. Judges created the law. Keshavanand Bharati versus State of Kerala. Basic feature is nowhere defined in our constitution, but judges made the law that parliament cannot amend basic feature. This is a proof that judges are making law through doctrine of stare decisis and ratio decidendi. Husainara Khatun versus Home Secretary Bihar. If a under trial has undergone half of the punishment, he is entitled to be released on bail. Later on, CRPC was amended, and this provision was incorporated in section 436 capital A. Ratio was that Article 21 gives right of speedy trial as a fundamental right to every citizen and human right of prisoners. If he is in jail, half of the penalty he has already undergone, judgment is yet to be pronounced, you never know when judgment will come, at least he should be released on bail. This is another example of law created by Supreme Court. I told you later on CRPC was amended. Then Vishakha versus State of Rajasthan, the directions were given by the Supreme Court, and later on Parliament crystallized those directions in the shape of an act known as Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act of 2013. Best proof of judges made law. Then DK Basu versus State of West Bengal, directions were given by the Supreme Court and then CRPC was amended. Shaira Manu versus Union of India, triple talaq declared unconstitutional. Best proof that judges are making law. And recently Supreme Court has decided that if a wife is living separately from her husband under decree of judicial separation, she is also entitled to maintenance under section 125. Again judge made law. This is the result how to find out ratio decidendi. So dear students, you have ample examples, ample proof that judges do make law through doctrine of judicial precedent, and law declared by Supreme Court is binding on all the subordinate courts within the territory of India. That is judge made law. The nutshell conclusion is what Supreme Court said in Dina versus Union of India. They said that ratio of a case can be extended to other identical situations, factual or legal, but not mechanically, disregarding the rationale of that case. But dear students, sometimes a judgment is per incuriam. Per incuriam decision can be set aside by subsequent decisions. Again, the Supreme Court has said in A.R. Antule versus R.S. Naik. But what is per incuriam decision? Per incuriam literally means through lack of care. This doctrine means that court, while pronouncing the judgment, has failed to pay attention to the relevant statutory provisions or precedent. Hence, per incuriam judgment need not be followed by the lower courts. They are free to depart from a decision of a superior court where the ratio decidendi is per incuriam against the express provisions of the law or well-established judicial precedent. Similarly, dear students, when a judgment is written sub silentio, doctrine of sub silentio says that decision is flowing when particular point of law involved in the decision is not perceived by the court to its mind. उस बात की तरफ ध्यान ही नहीं दिया गया, उस point की तरफ किसी ने neither one counsel nor the other counsel. The point was never argued or considered by the court. It was not argued before the court, so it is said to be passed silently. So dear students, the ratio decidendi of decisions passed sub silentio is also not binding on the courts. Why? The entire discussion is based on doctrine of stare decisis. The law is emanating through consistent following of the ratio decidendi. Stare means to look constantly with concentration. हिंदी में बोले तो किसी चीज को एक टक देखना. पुराने जजमेंट को एक टक देखिए, स्टेयर करिए, and then write the decision. Stare decisis means to stand by the decided cases or let the decision stand or maintain former adjudication or follow the ratio decidendi in similar and identical cases. And this doctrine is adopted in our constitution by virtue of Article 141, which declares that decisions of higher courts are binding on subordinate courts. Similarly, the decisions of high courts are binding on subordinate courts of their jurisdiction. Thus, law declared by Allahabad High Court may be binding on subordinate courts in UP, but it is not binding on subordinate courts of Delhi or Uttarakhand. It can have only persuasive value. However, the obiter dicta of the high courts are also not binding on the lower courts. So dear student, this is the process of ratiocination. Ratiocination is the process of exact thinking or reason trained of thought And this ratiocination in law means following the ratio decidendi of cases regularly so as to give rise to law. Last question from your side, that what is the use of this trick in finding the ratio decidendi of the case? The first use is that you can reach at the correct position of law by this knowledge how to find out ratio decidendi of the case. Second benefit is that your dissertation, your research will be accurate to a great extent. Third benefit is that you can use this tool of finding out the ratio in moot court, and you can demolish the arguments of your opponent by saying that law cited by your opposite counsel is not the correct ratio of the case, and you can win your case easily. So thank you very much, dear students, for hearing me so patiently. If there are any questions, you are welcome. And over to Purva ma'am. Thank you very much.
Thank you so much, sir, for the extensive and pertinent discussion on ratio decidendi. I'm sure it will help the participants in the case analysis during their research. I would now like to invite our third speaker for the day, Ms. Priyadarshini Tiwari, to enlighten us with information regarding interview and case study method of data collection. But before that, I would like to request all the participants that the feedback forms of the respective speakers are being shared in the chat box after every after every speaker session. Kindly fill them up. Priyadarshini ma'am, over to you. Priyadarshini ma'am, are you here? Pardon me for a bit of inconvenience, everyone. The third speaker will be Ms. Soumya Sharma. Priyadarshini ma'am is having some technical glitch. She'll be joining as the fourth speaker. Ms. Soumya, are you here? We'll wait for a minute for ma'am to join. Thank you for your patience, everyone.
Hello, Pura ma'am.
Yes, ma'am.
Thank you.
You're audible.
Thank you. Thank you for inviting me. Okay. I think I'm not allowed to share my screen. Okay. Okay, is my screen visible to everybody?
Yes, ma'am, it is visible.
Okay, thank you, ma'am. Okay, good afternoon, everybody. I am here to talk about one of the techniques of data collection, which are called schedules. Okay, so today I'll be discussing about the definition, the types of schedules, the characteristics of a good schedule, how should a good schedule be formed, and what are in the meanwhile, when I discuss all of this, I'll also parallelly keep on discussing what are the limitations of a schedule, and also the difference between a questionnaire and a schedule. So I'll begin now. Schedule is a data collection tool, okay? And collection of data is very, very important for the kinds of research that we do. Schedule is a tool or an instrument that is used to collect data from the respondents. Schedule contains, and how can data be collected? As in the form of a tool, through questions, through statements that can be either opinions, and those opinions can be put in blank spaces or tables in the form of certain data, okay, by the respondents. So this is so the collection of all of this, the tool through which all of these things are collected in the form of questions or statements, or in the form of tables, can be called a schedule. Now, what are the characteristics or the features of a schedule? Now, the schedule has 3 to 4 features. The most important feature of a schedule is that it is presented by the interviewer, okay, who's called an enumerator. And this schedule is can be prepared by anybody, but is presented by the interviewer, okay? And he may ask the questions, and these questions will be noted down by him, okay? The list of questions is a mere formal document, and it need not be a very attractive document as such, okay? It's just you have to understand the basic thought process as to on what basis and on what guidelines do you need to ask those questions, what is the central area of the central theme of the research, and what is the plausible result, or the things that what is the objective basically that you're looking at, for which you have drafted or formulated this schedule. So that schedule will only contain that list of questions that are there in the schedule. Also, the schedule is it's a part of a very narrow sphere of social research, okay? So I would also like to elaborate a little bit about the enumerator. So an enumerator is specifically appointed for the filling of the schedule, okay? And they are, what is the purpose of appointing them, and what is the objective that they achieve? So enumerators are basically those people who explain the aims and objectives of the investigation through which we are trying to, the investigation that we are trying to basically follow and answer through this schedule, through this observation data collection tool. Okay. So an enumerator explains the aims and objectives of the investigation and also removes the difficulties which a respondent or a person who's filling the schedule may feel in understanding the implications of a particular question or the definition or the concept of the terms that are used in this schedule. Okay. So it is very important because you may realize that this enumerator is a person who is basically explaining the questions, basically trying to put forth the questions or the things, the data that is basically asked to the person who's the respondent. Now, if this person enumerator is fulfilling such an important task, the selection of an enumerator also is very important process as far as the formation of a good schedule and the collection of data is concerned. So an enumerator should be very carefully selected. Okay, then so that is why it is important that the enumerators should be very trained to perform their jobs and understand the nature and the scope of the investigation, and that nature and scope of the investigation should be very thoroughly explained to them so that they may understand the implications of the different questions that are put in the schedule. Enumerators, therefore, should be very intelligent and must possess the capacity of cross-examination in order to find the truth. Also, they should be very honest in their approach towards the research. They should be very sincere, hardworking, and should have a lot of patience as far as the job, the activity that they're concerned with is dealt with, because with patience comes the tact of understanding what they want to collect, what are they there for. Okay, so that is very, very important. Then the purposes of a schedule are therefore threefold, you have to understand. First of all, because it is a data collection tool, it provides a standardized tool for observation or interview in order to obtain or attain objectivity. Okay. Schedules also help as a memory tickler. What is a memory tickler? The schedule keeps the memory of the interviewer / the observer refreshed and keeps him reminded of the different aspects that are to be particularly observed. So in a schedule, the type of questions or the type of data that you are collecting helps you to keep tabs on what are the things that you need to keep coming back while you are researching. So, and also it may give you an in-depth idea as to what are the things that you would want to investigate or observe. So a schedule is a ready reckoner basically that reminds you or takes you back to the things that you need to investigate and observe. And also through the observations of the schedule that you have collected from the respondents, it helps you to facilitate the work of the tabulation and analysis. So a schedule is a go-to document, formal document that you prepare, which keeps you in the loop and of the research, and it can bring you back as to the things that you would want to cover in the investigation of the research. Then, what are the types of schedules? There are 4 types of schedules. The first type is the rating schedule. Now, what is a rating schedule? Rating schedule is a schedule used to obtain opinions, preferences, etc. of the respondents over statements on the phenomena studied. So basically, rating schedules is a type of schedule in which there can be open-ended statements that can be filled in blanks. And these statements can be opinions and preferences of the respondents that are present. And this preference, of the respondent can be either a positive statement or a negative statement of opinion on the phenomena that is being studied. Okay. The next kind of schedule is document schedule. Now, what are document schedules? Document schedules are used to collect data and information from recorded evidences and or case histories. So, for example, the blanks that are used, the blanks, the functional issues related blanks and the like to be filled up from records and documents that are present. Then there are survey schedules. Survey schedules act as questionnaires. So basically, any kind of a questionnaire that has the objectives that are supposed to be achieved that those questions can be put into a form of a schedule, and that is called a survey schedule. Um, One very important information also related to survey schedules is that the population census that is done all over the world is conducted through this method of data collection through survey schedules. Then also, observation schedules are the last types of schedules. What are those? Observation schedules are schedules that are used when observational method of data is being collected. These could be structured or unstructured interview schedules and are used for collecting data when interview method of communication with the respondents is used. So when you're using the interview method of data collection, the kind of schedules that you put into use is the observation schedule. Then how do you formulate a schedule? And what are the things that you need to keep in mind when you're creating or drafting a schedule for the purposes of your study? So first of all, to be able to understand, you have as to what do you need to put in the schedule so that proper results can be studied, or to understand and bring out the proper results. So you have to firstly understand what is the problem that you are studying. Okay, so the different aspects of the
हाँ जी मैम
okay, different aspects of the problem need to be studied. So the problem under study should first be split up into various aspects, and the determination of these aspects will depend upon the clear understanding of the problem under study. Then you have to subdivide the problem to get the necessary information. So each aspect has to be then broken down into a number of subparts. Okay, and these subparts should be quite exhaustive to give a full and complete picture of the aspect under study. So basically, you have to understand the problem first. What is the problem that you are trying to determine? Through that problem, that is a bigger problem, you have to divide that bigger problem into subparts. And with the help of subparts, you will be able to understand the complete picture that is under study for a better understanding of the drafting of schedules. Then you have to prepare something as called as a class question. Now, what is that? There should be a proper care that should be taken to see what the questions convey in the exact sense. So you have to, while you're drafting a schedule, always go back to the kind of questions that you're putting in the schedule, so that you may understand the kind of answers that can be the possible answers. So the permutation and combination of the questions should be unknown to you, as to understand what kind of possible answers can be recorded in that schedule. The respondents will be willing to supply information without any hesitation, bias, or distortion of facts if questions are clear and exact. So this kind of an understanding will lead to a non-bias and a distortion of facts, non-distortion of facts, because if your questions are exact, if your questions are not open-ended questions, if your questions are clear, then the kind of answers that are recorded will be bias-free, which is very important for a good data collection. Then serialization of questions. Now, it is very important to also understand that the kind of questions is one thing, but how do you put those questions and in what order is also very important. So in order to obtain a well-organized information, it is necessary that the questions should be presented to the respondents in a well-ordered serial. Because we also, when we fill up certain questionnaires or in schedules for that matter, we realize that the order of the questions sometimes creates a different kind of an experience had it been in some other form. So it has been experienced that various field studies change the order of questions. In the changes of order of questions also affects the answers adversely. So how do you put your answers, questions in a schedule is also very, very important, the order of the questions. Okay. Then testing the validity of the schedule. Whatever may be the degree of precaution taken, some slips are obviously cannot be avoided and are based to be left out, and these can be located when the schedule is put into a reliability and a validity test. Okay. Then division. The schedule can be divided into adequate number of divisions. For example, there can be an introductory part, then there can be an instructional part where you put in down the instructions as to how the respondent is supposed to be filling that schedule. Okay, then if you want to put certain notes regarding the issues that are to be taken care of while filling the schedule, then you can put those that there. And these should basically, it's not like a schedule is just a series of questions put together. How a question needs to be addressed can also be put into that particular schedule. Okay, and it is very important also for a good schedule to come up is that the questions that you put are firstly put in appropriate order that we already discussed in the serialization of questions, but also uh, you have to use appropriate forms of questions at appropriate places, which means what do you mean when I say appropriate forms? I mean to say that the questions should not be, first of all, a question which has a subjective question basically. Okay, and the questions should not be open-ended. Questions should always be direct and close-ended, and there can be yes or no questions that can be asked. If you want to understand if there is a subjectivity that you can, if you can afford a certain level of subjectivity in your research, then you can obviously ask questions which are probably either multiple choice, or you can formulate your question in such a manner that there can be a written statement that can be given in the form of an answer to the question. So that can be also done. Then what are the essentials of a good schedule? That the things that we discussed were the things that are required to formulate a schedule. Now, how do you formulate a good schedule? What are the things that you need to keep in mind? Is first of all content. Content should cover questions or statements relating to all the significant aspects of the study. Then it should not be a very see, it is very important that data collection is an objective uh, inquiry. So subjectivity should always be thrown out of the window when you are trying to do any kind of data collection, be it through interview method or through schedules. But you should also, so why is that? Because objectivity leads to analysis, a good analysis. So you should be very, very dissectional in your approach as far as a good schedule is concerned. So why is that? Because a good dissectional schedule looks into the problem analytically. And why? Because it then dissects every major and significant component of the problem. Then next is the context. The context should, the schedule should suit the context in which it is applied. And how is that taken care of? That is taken care of with the help of the types of schedules that are there. So the 4 types of schedules cater to 4 kinds of data collection. And what kind of data do you require to collect depends on the on that depends the type of schedule. So the context of the schedule is also very, very important. Okay. Then there should be a certain criterion. You have to what you're trying to ask should also depend on what is the objective that you sought to achieve. So there should be a, when you classify your data, when you put questions in a serial order, there should be a certain level of logic behind it, because the logic will classify the opinions that are based on which your data collection is based. Then the schedule should be constructed in such a way that questions and statements progress gradually and in order. It is better that it is subdivided into parts, each part requiring with a certain subtopic of the issue that is to be studied. For each objective that you're trying to achieve, there should be a separate part that may be devoted. Then the words and the language and the grammar and the punctuations that are used should be very, very properly used, because a punctuation can change a lot of connotation. A word used differently can change a lot of connotation of the question. So the grammar should be perfect, and there should be straightforward questions, and the language that is used should be very straightforward. So, and that obviously, because that obviously then deletes the possibility of subjectivity in the schedule. The schedule should be reliable such that the results that are obtained can be used when all the other variables change also. So that is very, very important for you to remember. Obviously, the technical and the mechanical aspects of the schedule is also very important. How lengthy can an answer possibly be should be something that you should always keep in mind. So the kind of space that you provide, the kind of margins that you use, okay, the size of the letters that you are asking, that you're using to put down for a question should be properly and analyzed, and then you should be drafting a schedule. Uh, then qual like when I say subjectivity, I say that a long, complex, or an embarrassing or presumptuous issue, or a hypothetical issue that may have a possibility of an orientation of whatever sort, moral or otherwise, should be avoided at all costs. Okay. So these are the points that you need to remember when you are talking about a good schedule, a formation, or the essentials that are there present for a good schedule. Now, somebody may ask, or somebody may think that what is the difference between an interview and a schedule? Because by the look of it, it looks more or less like an interview. But there are many differences that are there as far as an interview and a schedule can be contrasted. So uh, both are for your understanding, it is important to understand that both interview and schedules are properly used methods of data collection in research surveys. But it is important that there is much resemblance in the nature of these two methods. And in fact, from a practical point of view, a lot of people may say that both of them are same. But as far as this technical aspect of the subject is concerned, interview and schedules are both two very different methods of data collection. There are many points of difference, and what are they? I'm going to discuss now. The questionnaire, first difference is that the questionnaire, first of all, can be sent through an email, okay, that has to be answered as specified in a covering letter. You can send an interview through in a covering letter through the mail, but that does not require a lot of assistance as far as the sender is concerned. But the schedule is generally filled out by the person who is either researching or by the enumerator who is appointed by this researcher, who can interpret the questions when necessary. Okay, this is the first difference. Then the second difference is that to collect the data through questionnaire, it is relatively cheap and economical. Okay, because you only have to spend money in drafting or preparing the questionnaire, and then you can mail that to your respondents. But so basically, you're trying to say that there is no enumerator as such who is required. But to collect data through a schedule, it is more expensive an affair, because a considerable amount of money obviously will be spent in appointing enumerators and in training them also as to how this schedule needs to be filled. So basically, the interview method is a cheap method, and schedule method is an expensive method of data collection. Okay. As far as questionnaires are concerned, one very important difference, which is the third difference, is that non-response or non-responsive questionnaires are, the possibility of that is usually high as far as questionnaires are concerned, because a lot of people may not return to the questionnaire or may not respond to the questionnaires at all, because of that, a bias of non-response may creep into it. Okay. But as far as schedules are concerned, non-response is very low. The possibility of non-response is very low, because it is either filled by enumerators or the person who's doing the research. So the possibility of non-responsiveness may decrease. Okay. Also, in an interview, the possibility of a bias and a possibility of cheating may be there, but as far as schedules are concerned, the possibility of that remains controlled. Okay. In the case of a questionnaire, it is not always clear as to who is replying, but the person in the case of a schedule, the person who is the enumerator or the research scholar himself knows as to who is the respondent, what is the identity of the respondent who has filled this particular schedule. Okay. The questionnaire method, that is likely to be very slow since many respondents do not return the questionnaire in time despite several reminders. But in case of schedules, the information is collected at that particular moment only or well in time because they are filled by the enumerator. So that time frame is also very, very important, and that is one of the primary differences. Then in case of questionnaire method, personal contact between the respondent and the research worker or the enumerator is not possible, which is possible in the case of a schedule. Direct personal contact is established with the respondents. Okay. Questionnaire method can be used when respondents are literate and cooperative because they know they will read it by themselves and will be able to answer. So only literate people can answer questionnaire method. But in case of schedules, the information can be gathered even by the respondents who are illiterate because the questions can be explained to them by the enumerator in his own language, the languages that they understand, and then the data can be collected. But yes, there is a possibility that a more wide and representative distribution of sample is possible under the questionnaire method. But in cases of schedule, there usually remains the difficulty in sending enumerators over a relatively wider area. Also, the difference is that risk of collecting incomplete and wrong information is relatively more under the questionnaire method, where it is a possibility that the people may not be able to understand the questions properly. But as far as the schedules are concerned, the information collected is generally complete and accurate, as enumerators can remove the difficulties, if any, because they are trained to do that are faced by the respondents in understanding their questions and also able to answer them. Therefore, the result is, what is the result? The result is that the information that is collected through schedules is more, the possibility is that they are more accurate, okay, as far as the questionnaires are concerned. Then the success of a questionnaire method lies more on the quality of the questionnaire itself. But in the case of schedules, much depends upon the honesty and the competence of the enumerator. Then, in order to attract the attention of the respondents, the physical appearance of the questionnaire must be quite attractive. But this may not be in the case of schedules, as they are to be filled in by the enumerator and not by the respondents. Also, the last difference is that along with schedules, observation method can also be used, but such a thing is not possible while collecting data through questionnaires. So when we discuss all of these differences, we also are able to highlight the limitations of a schedule method. A schedule method as compared to an interview method is more limited in approach because, first of all, it's a very costly affair. And it requires to draft a schedule requires a certain level of understanding and expertise as compared to an interview method. It is more time taking. Interview, on the other hand, that is why it is more time taking to formulate a schedule. But once a schedule is formulated, data collection becomes quick, which is as compared to an interview method of data collection that is quicker. So with this, I would like to end my deliberation. I think I've covered more or less as far as schedules are concerned. Thank you, ma'am.
Thank you so much, ma'am, for informing us about the know-hows of schedules. I would now like to invite our fourth and last speaker for the day, Ms. Priyadarshini Tiwari, to provide us with information regarding interview and case study method of data collection. Over to you, Priyadarshini, ma'am.
Thank you, Purva ma'am. Thank you so much. Am I completely audible and visible to everyone?
Yes, ma'am.
Okay. Purva ma'am, please allow me to share my screen.
Yes, ma'am, we've allowed you.
Oh, thank you, ma'am. Okay, is my screen visible?
Yes, ma'am, your screen is perfectly visible.
Okay, fine. Okay, good afternoon, everyone present here in the meeting. First of all, I would like to thank our respected HOD, Professor Pallavi Gupta ma'am, and the organizing committee of this event to provide me an opportunity to speak on the assigned topic. So the topic on which I'm going to discuss is the interview method of data collection. So my dear students, before starting with the interview method of data collection, I would tell you about the data collection. What is data collection? Yes, collection of data is the most important aspect of a research study. And with the collection with the collection of data and handling of a data, the researcher begins to feel more excitement about the research. So my dear students, as you are attending this lecture series in this workshop, so you must be aware with all the details, tool and techniques of data collection, and that is why here I'm not going to discuss with you the entire tool and techniques of data collection, but I will be very focused with the topic which is specifically assigned to me, that is the interview method of data collection. So in this lecture, I will discuss the introductory portion of interview method, the definition of interview method, the types of interview, the method of interview, and the steps which are required to be taken while conducting an interview. So firstly, what is interview? So my dear students, interview is the oldest and often used device of data collection. It is most often used device to gather information among the human beings. As a data collection technique, it is a verbal method of securing data, and it is to be conducted with a specific purpose in the mind of the interviewer. It may be the interview may be conducted either face to face or through telephone or through internet process, and it can be conducted for basically interview method of data collection simply means the conversation, the verbal conversation two person in order to obtain information on a particular social problem. So basically, an interview is generally a qualitative research technique which involves open-ended question to converse with the respondent and collect illicit data about a subject. The interview in most cases is the subject matter, except when intends to understood the respondent's opinion in a well-planned and executed series of question and answers. Now coming to the definition of the term interview. So my dear students, different scholars have defined interview methods as per their own understanding and wisdom, but I have taken few of them. So as per the definition given by the scholar Good and Hart, interview is a close face-to-face conversation or a dialogue between the investigator, interviewer and interview. So as per the definition of Good and Hart, interview is only a conversation or a dialogue between the two persons in order to seek the opinion on any social problem which is the subject matter of a research study. Next, the next definition I have taken is the definition given by Krillinger, and he has said a face-to-face interpersonal situation in which one asks question from the other to get answer about any social problem. So we can, after the analysis of the above mentioned definition, we can say interview method of data collection is basically a conversation between the two persons in which one person asks the question and one person answers the question asked to him. The person who asks the question is called the interviewer, or and who is answering such question is called the respondent, interviewee. So this is basic definition of interview method. Now I will focus on the fundamental types of interview. So basically there are three types of interview. The first one is structured interview. The second one is semi-structured interview, and the third one is unstructured interview. So firstly, I will discuss with you structured interview. So structured interviews are defined as research tools that are extremely no scope of promoting the participant to obtain and analyze the results. The structured interviews are also called the formal, or controlled interview. It is also known as standardized and quantitative in its approach. The questions which are asked in a structured interview is basically pre-decided according to the required details of information. Now, the characteristics of structured interview. Basically, the first characteristics of the structured interview that there are same series of questions. In a structured interview, the same series of questions are to be asked to each and every respondent. There is no separate question for each and every individual. The pre-decided questions and limited set of response category. In a structured interview, we can easily see there is pre-decided questions and there is very limited scope, there is very limited response category, and lastly there is little room for variation in responses. As I already told you, there are very limited response category, and that is why there is very small and very little chance of variation in the responses. And the role of interviewer. In the structured interview, the interviewer plays a neutral role and acts very casually and friendly, but does not insert his or her opinion in the interview. And next, the semi-structured interview. The semi-structured interview offers a considerable amount of leeway to the researcher to provide the respondents along with maintaining basic interview structure. The semi-structured interview is also called the guided, controlled, and formal interview. Even it is a guided conversation between the respondent and the interviewers, an appreciable flexibility is offered to the respondent. A researcher can be assured that a multiple interview round will not be required to the presence of in the presence of structure. And the interviewer and the respondents engage in a formal interview in a semi-structured interview. Next, the interviewer develops and uses an interview guide. Now, what is interview guide? Interview guide is basically a written document in which details of topic and questions are mentioned, and a list of question or topic that need to be covered during conversation, usually in a particular order. So basically, these are the Purva ma'am, am I audible?
Yes, ma'am, you're audible now.
Okay,
Please continue,
ma'am.
ma'am.
Okay, ma'am. Actually, there is a lot of internet disturbance. Okay. Now, unstructured interview. I was talking about unstructured interview. So, unstructured interviews are basically called the informal interviews. It is unguided and undirect interview. It is also called an interview in depth. Usually, it is described as a conversation held with a purpose in mind to gather data about the research study. These interviews have the least number of questions as they lean more towards the normal conversation but with an underlying subject. Now, the object of unstructured interview. The main object of an unstructured interview is to build a bond with the respondents, due to which there are high chances that the respondents will be 100% truthful with their answers. And in unstructured interview, there is no specific guideline to be followed by the researcher. As I have already told you that unstructured interview is unguided interview. So there is no specific guideline which are to be followed by the interviewer or the interviewee. And the basic characteristics of the unstructured interview. Engage in a formal class. My dear students, I am facing very bad connection issue, but just wait for a minute. And in the last, I will discuss with you the method of interview. So basically, there are three methods of interview. That is the personal interview, telephonic interview, or interview through email or web-based interview. So firstly, I will discuss about the personal interview. So basically, personal interview is the most used type of interview where questions are asked personally and directly to the respondents. Now, what are the merits of the personal interview? In personal interview, there is very high response rate. In the personal interview, there is very high interest. There is very high response rate, and when the interviewer and the respondents are face to face, there is a way to adopt the question if it is not understood. And the next merit of the personal interview is that more more complete questions can be obtained if there is doubt on both sides or particular information is detected that is remarkable. And the researcher has an opportunity to detect and analyze the interviewee's body language at the time of asking the question and taking note of it. Now, what are the demerits? So in personal interview, the personal interview are very time consuming and expensive. There are very high chance of distrust, and there is lack of anonymity, and there is also chances of interviewer biasness. So these are the merits and demerits of the personal interview. And I'm just concluding my presentation here because the place where I'm sitting right now, there is very much internet issue. So thank you so much. Thank you, everyone.
Thank you so much, ma'am, for sharing such elaborate insights on interview and case study method of data collection, despite all the technical glitches that you were facing. We have now come to an end of today's session. I take this opportunity to thank all the speakers for their valuable contribution in today's session. I look forward to virtually meet you all tomorrow at the same time with new research related topics of discussion and new speakers. Thank you all for being such patient listeners. I hope you all have a good day ahead. Also, before we leave, I request everyone to kindly switch on their cameras so that we can take a group photograph for today's session. Everyone is requested to kindly switch on their cameras for a group photograph.
All the students, speakers are requested to switch on their cameras for a good group photograph. All the students.
Thank you, Richa ma'am. Everyone can leave the meeting now. Thank you.